Let's move on to the Supreme Court. America's 9 most fascinating legal scholars or 9 most boring wizards. Marriage equality wasn't actually their only major ruling this week.
Today, in a landmark 6-3 decision, the Supreme Court voted to uphold nationwide subsidies to help poor and middle-class Americans purchase health insurance under the Affordable Care Act.
It's amazing. Somehow, against all the odds, Obamacare is still alive. It's the legislative equivalent of Keith Richards. It really could have died in so many ways by now, but I'm definitely glad it's still around. There was genuine concern that this case could have dismantled Obamacare completely, and if it had, it would have been for the dumbest possible reason.
The challenge was based on these 4 words, quote, established by the state. Opponents said the phrase made federal subsidies illegal in certain states.
Yes, established by the state could have been the 4 most damaging words since Godzilla just joined ISIS, or piranhas now have legs, or mom's on Facebook now. Luckily, the Supreme Court realised that, in context, the state meant the government and not one of the 50 states. But Chief Justice Roberts did point out that the law could have been clearer.
Roberts acknowledged the law contains more than a few examples of inartful drafting, but he said the opponent's approach would lead to a calamitous result.
And that's true. Inartful drafting put 6.4 million people's health coverage at risk, which is insane, because language is inartfully drafted all the time. For example, let me show you an actual banner supporting England's Women's World Cup team this year. Come on, our girls. That sentence really could have used a comma. Just throw a comma in there. But like the Supreme Court, you fundamentally understand the intention behind it. Nobody's arguing that we should literally do what it says. Now, this landmark decision inevitably drew a dissent from Antonin Scalia, a pizzeria chef statue that came to life but never acquired human emotions or empathy. And Scalia was emphatic in his response to Roberts.
His opinion sparked a blistering dissent by Justice Antonin Scalia, who took the unusual step of summarizing it from the bench, calling the court's reasoning absurd, interpretive jiggery-pokery, and pure applesauce.
I'm sorry, jiggery-pokery, pure applesauce? Are you a justice or a Victorian dowager writing an angry letter to Prim and Proper Ladies Monthly magazine? Listen, Scalia, let me answer you in terms that I think you'll understand. Because, yes, the court's ruling was a bit frippity-frappity, but I say this, if it takes a touch of goofery and baba ganoush to help keep the people of this great nation healthy, well then, by Hiblet or by Giblet, bring on the hoople and zizzle-zazzle, because that's the kind of country I want to live in. I said good day, sir. Blueberries and custard, sir. Blueberries and custard. And lastly,